Good morning to you all, and thank you very much for attending this session about becoming an effective trustee. Um, my name's James Sinclair Taylor, and I'm presenting this with my colleague Sukanya. We both work in the governance team of the charity and social business team. The charity and social business team covers a wide range of issues from property, staff, employment issues, data protection and health and safety, contracts and funding and mergers. And we're part of a much larger firm, Russell-Cooke, with over 150 lawyers who deal with pretty much everything from litigation through planning to commercial issues, property, medical negligence, you name it. So thank you all for coming today. There are a lot of us, and so we are going to use the question and answer box if you wish to ask questions. We thought it would probably be easier, given that this is a complex subject, to deal with those at the end. This is an hour-long seminar, and we're quite happy to hang on for those of you who've got the time and had a question that hasn't yet been answered. So please do keep putting your questions in the box, and we will get to them at the end, and we will run over if it's necessary. If we get a real deluge, we will email answers or set up contacts with you to deal with your questions separately. And both Sukanya and I would be very willing to deal with any questions that you want to just approach us about separately on another occasion. Our contact details are in the last slide, and you'll be sent all the slides. So thank you again for coming. And just where do we start? Well, to be honest, the issues of where a trusteeship can go wrong often start at the very beginning. I think people have got a lot better at it, but the whole selection and induction process is absolutely vital for ensuring that things go right. So in my experience, it often took, when I first started being a trustee, 12 or 18 months for me to really understand what was going on, because there essentially wasn't an effective induction process. So you didn't have checks on whether you'd been properly appointed. You didn't have proper forms being completed to ensure that you were eligible, nor did anybody ever explain the Constitution to you. And it may sound a little odd, but we do quite a lot of governance audits for people. And when we do that, we quite often find that a board has largely not been appointed in accordance with the Constitution, and so that the board itself is improperly appointed. So when you're asked to join a board of trustees, it may sound an odd thing to do, but do contact them and say, well, exactly how was I appointed? For example, quite a lot of boards co-opt people, but normally there's a limit on the number of co-options for any board, and it may well be that they've already exceeded that. In terms of induction, there is the formal induction, and nothing beats reading back, understanding the accounts, looking at the Constitution, and of course, getting out there and visiting the activities on the ground. But there's also the informal induction, and it's great to have one-to-ones. Many organizations will set up a buddy system to ensure that a new trustee finds their way around quickly. As well as getting out there and visiting, having conversations with staff where you have them is vital. Doing some web searches about what the history of this organization, looking to see if your charity is involved in a sector where there are publications and asking the organization to copy you in on them. Maybe your organization's part of a wider movement or alliance, or maybe there are sister charities nearby. It's really important to try and get a rounded understanding of the area in which you're trying to deliver your duties. And finally, when we talk about a rounded understanding, trustees are a team. They really only do well if they are working together in an attitude of mutual trust. And in order to get there, they've got to socialize together. And so I know it's been difficult during COVID, but for example, in a couple of charities that I chair, we have a drinks on the night before a board meeting for an hour so that we can meet in a less formal atmosphere and try and replicate getting to know our fellow trustees in the way that we used to. This is particularly important where you're joining or have joined during COVID, because you haven't had a chance to build up the face-to-face contact, which is so vital. So these are the key issues that you need to be aware of. And when we talk about the Commission's guidance, I think the one document that all of us need to read and occasionally reread, even if we're quite experienced, is the Charity Commission's Essential Trustee, where they've tried to boil down into one document everything that you need for doing the job. Clearly, we're a huge and varied sector, and things are very different between sectors, so you have to make allowances for the special needs of your sector. So talking of boiling things down, the Charity Commission sought to boil down the what it is to be in charge of governance. And they created a sentence which encapsulates what they think is all that they care particularly about. And this sentence breaks down into sort of 7 key things. So firstly, you're ultimately responsible. So when we take on a trusteeship, we take on personal responsibility, and that's a responsibility which we owe to our beneficiaries, but also directly to the Charity Commission. Secondly, you are, even though you may not feel like it when you first join as a trustee, actually directing the charity. So how are you going to do that? What is the reality of your organization? Are you reviewing the work of highly qualified staff? Are you delivering the work directly yourself? Gain an understanding of what it is for you to direct this charity. Ensuring it's solvent is obviously critical. So the accounts people often concentrate on, but they're a historical record. And if you've got a set of accounts, it meant that you survived that period. What you really need to be watching for is the cash flow, looking at where your reserves are. Have you set them at a sensible level? Are you taking the difficult decisions? I mean, sadly, one of the things we as trustees have to do is to take the difficult decisions, sometimes decisions that staff are not particularly keen to take, about maybe cutting down on certain areas, or indeed laying people off, or in order to stay within sensible financial boundaries. And finally, in the area of finance, do you have financial controls that actually safeguard the money that you've got there? So then you're responsible for ensuring that the place is well run. Well, you've obviously got to set high standards. You've got to ensure that you've got a chief executive who's going to be up to the challenges of what you're doing. It's almost the most important thing that we do as trustees is select, support, encourage, review, and occasionally remove and replace a chief executive. If you haven't got an effective staff leader in the organization, you're going to have a hell of a job as trustees making it work well. Then you've got to deliver charitable outcomes. Well, that means looking at your objects, and many of us don't pick up the constitution that directs our charity often enough, and it is that first page or so which sets out the objects, which is crucial because it's rather strictly interpreted. And if you're a charity set up for the blind of Richmond, you can't be working in Hounslow. If you're a charity set up for people with learning difficulties, you can't also be working with people who've got substantial mental health issues which aren't learning difficulties. People often forget that what we're here to do is not just do good, but to achieve particular outcomes. It's got to be for the benefit of the public. The Commission's got a good publication, and you've got a duty to read that publication about what that is. And you've got to ensure that the organization stays on track to deliver these things. So, Rachel, this is how the Charity Commission has boiled down your duties into 6 key things. And as I said, if you go through the Essential Trustee, and particularly if you're interested in the areas, it's very helpful. You've got a lot of links to their other guidance. And then you've got to think, well, okay, here's all these things I've got to do. How is it that on the board I'm going to behave in order to make these things happen? And I think there are a series of behaviors that you might exhibit in any board meeting. They might be testing what you're being told, kicking the tires on a report as to whether it's ambitious enough, whether the assumptions have really been tested. It might be stretching. It might be saying, well, we aren't set up for growth in the coming year. Why not? It would be great if we could be working towards some larger delivery of our service. But it's also about supporting the staff. Staff, and particularly the chief executive, have pretty lonely jobs, and without support and encouragement and celebration of success, you're not going to be able to have the sort of well-motivated staff team that are going to help you deliver these outcomes. Sukanya.
Thank you. Rachel, if we could just have the next slide. Thank you. So in addition to the duties you have as a trustee of a charity, if your charity is established as a company limited by guarantee, which many of your organisations are, you also have duties under company law. And the overriding duty is to act in a way you consider in good faith would be most likely to achieve the company's purposes. And that's reflecting back on the charitable objects of your organisation. Ensuring, for example, you're there to, relieve poverty or to advance education, and you must ensure that you don't enter into any sense of mission drift by acting beyond your objects. If you're a non-charitable company, you're obviously there to promote the success of the company for the benefit of its shareholders. So that's quite different in relation to your statutory duty under company law. Next slide, please, Rachel. So these are the other duties under company law. You also need to act within your powers. Now, your powers are not just your objects, but also the additional items that you often refer to directly below your objects in your articles. So, for example, the ability for the organisation to enter into contracts or to employ individuals or to give security arrangements for the charity. To the extent you act beyond your objects or beyond your powers, you're seen as acting ultra vires, and that fundamentally means that you could potentially, it is quite rare though, be found liable in respect of losses to the organisation if you've acted beyond your objects or your powers. As trustees of a charitable company, you're obviously registered at the company's house, as well as with the Charity Commission. And as your trustee duty, you must ensure you exercise independent judgment. And what that fundamentally means is that you're not going to be swayed by an overbearing member of the board, and that you will have your own discretion and determine your own decision. But once a decision is collectively made by the board does need to move forward on that decision and move forward collectively and not reopen that decision unless there's new information that may come to light. You also have a duty to exercise reasonable care, skill and diligence. Now, this is both an objective test and a subjective test. It's objective in the sense that you must have the level of reasonable care and skill that one would expect of somebody who's carrying out the role of a director of a charitable company. But in addition, it's subjective. So, for example, if you're a day job, you're a finance director of a company listed on the stock exchange, you'd be expected to have a higher level of skill and care in relation to financial matters than the average person carrying out that role. The next three duties are quite linked. It's all about really integrity. It's a duty not to accept benefits from third parties, say for doing something or not doing something in your position as a trustee. Similarly, you have to ensure that you declare interest in any proposed transaction or arrangement with the charity that you might directly benefit from. And this links to this whole concept of conflicts of interest that you might have as a result of your loyalties to another charity or to an employer, as well as them conflicting with the interest that you have and the loyalties you owe to the charity of which you're a trustee of. And James will be talking about that in a bit more detail later. Next slide, please, Rachel. Thank you. So as a charity registered with the Charity Commission, you're obviously going to be regulated by the Charity Commission. Over the years, particularly the last 5 years, we've seen the Charity Commission become much more regulator of charities as opposed to being a champion of charities. These two initial points, holding charities to account and dealing with wrongdoing and harm, are two of their key strategy objectives of their 2018 5-year strategy. These resulted particularly as a result of many household names having issues relating to how they were running their organisation. Many of you will remember the issues that arose with Oxfam, a well-known household name charity, following sexual misconduct issues and allegations that arose during its time of aid workers working in Haiti after the earthquake in 2010. As a result of that, there was obviously a knock-on effect, not just for Oxfam, but for the reputation of the sector as a whole, and also for the Charity Commission. The Charity Commission believes that all charities should be held to a higher standard of behaviour, conduct and integrity than the average organisation. And the way that they're looking at this is by ensuring that charities report serious incidents. I'll be looking at that in more detail, but fundamentally a serious incident is a situation where an incident takes place, alleged or actual, which results in potentially harm to your beneficiaries, to your assets of your organisation, or even simply to the reputation of the organisation or the sector. The Charity Commission is very hot at the moment at looking at anything in the media which may affect charities generally, or in particular your charity. They're looking at not just the broadsheets and the tabloids, but obviously in relation to anything now that's on social media. So if you have a membership organisation, for example, some members will put out statements on social media, relevant tweets, which may be inappropriate, may not even be factually true, but could detrimentally affect your organisation. And you need to react to that appropriately before the Commission potentially sees it and inquires what's happened. We've seen also with Oxfam only just recently, they're not out of the woods yet, because only last week 3 members of staff were removed or dismissed as a result of further allegations which were substantiated in relation to sexual misconduct in working in Democratic Republic of Congo. Next slide, please. So as a registered charity, you're regulated by the Charity Commission, and the Commission puts out a significant amount of guidance. James has already referred to, in particular, CC3. I have put at the end of the presentation various guidance that I do suggest you look at. During COVID year of 2020, they also put out additional guidance to encourage charities to ensure that they were still financially compliant and were not going to go under during COVID times, and also additional guidance regarding your objects, ensuring that you're working within your objects. As a charity, you do have to report back to the Charity Commission annually. That's not only just with your annual report and accounts. You do also have to submit an annual return to the Commission, and you must ensure that you submit these documents on time. If you don't, on the Charity Commission register, which is available on their website, it will highlight you in red and notify that your accounts are overdue. The Charity Commission can also issue what we call official warnings to charities. These tend to be where they believe that there might be any form of financial mismanagement or misconduct or any breach of those duties which we've just discussed. And what they can do is actually put this on their website. So immediately you have a reputational issue potentially if that happens. The idea of official warnings are fundamentally to ensure that the Charity Commission can work with the charity trustees in order to resolve any issues that might be occurring and also to prevent them occurring again. The higher level of regulation is when you have a statutory inquiry, which is what's happened with organisations such as RSPCA, Oxfam, and that's where they believe that there's going to be a serious issue taking place. It could be regulatory non-compliance, it could be that beneficiaries are being harmed, and then the Charity Commission will carry out a relevant report. Again, they will state on their website that they're carrying out a report in most circumstances, and they will also publish that report once it's done. They do also have the ability to remove trustees if they believe that the trustees are not acting appropriately, or if there's financial misconduct or mismanagement within the organisation. They can even also close a charity, and they can intervene in other ways by, for example, giving directions that certain activities are not to continue or that assets potentially may be frozen. Next slide, please, Rachel. This slide simply sets out from the Charity Commission website the areas of investigations and compliance that the Commission has been involved in during 2019-2020. And what we've seen is a significant increase in the number of whistleblowing reports, for example. They've increased by 34%. And serious incident reporting has increased by 47%, although the Commission still believes that many charities are still not reporting enough serious incidents, and they believe there should be no shame in reporting serious incidents. It's more that shows that you're proactively managing your organisation appropriately. And statutory inquiries, which I just mentioned, they've been increased by 43% over that last year there. Next slide, please. So particularly in this changing regulatory environment, we've seen a real focus by the Commission on ensuring trustees comply with all their duties. There's the duties under charity law and under company law if your charity is set up as a company. There's a real focus now on your reputation of your charity. They believe that obviously anything that happens with one household name charity has a knock-on effect for that charity, but a huge effect obviously for the sector as a whole. There has been 248 charities subject to an inquiry just in 2019-2020, and I don't see that reducing. I think that will only increase subject to Charity Commission staff being available to carry out those types of inquiries. We've also seen the regulatory alerts increasing. In particular, June of last year, so just coming up to a year ago, there was an RNIB alert as a result of the conclusion of a statutory report into RNIB. It was quite a sad case in relation to that, where there was a specialist learning centre of RNIB, which was comprised both a children's home and also a school. And fundamentally, the Charity Commission became aware of safeguarding issues in respect of beneficiaries of that learning centre. And as a result of this statutory inquiry report, they actually issued a specific alert to all charities with an income of over 9 million, where they had a separate trustee board and a senior management team, which is quite standard in charitable companies, and where they were providing frontline services to beneficiaries. But that alert is quite useful for any charity to read, because it just goes to identify some of the governance issues that took place within that organisation, which failed to ensure that beneficiaries were well cared for. James.
Thank you, Sukanya. We focused a lot on the Charity Commission, and obviously it does bulk very large in all our concerns when we're trying to get things right. But you do need to think more broadly, and in order to think more broadly and to deliver your role well, you need to understand what people tend to call the business model, what you do as a charity and how you do it. If you don't really understand that, all the detail of it, then you're not really going to be in a position to work out what needs intervention from the board, what can be left quite safely for the staff. So areas which in the past have caused problems are fundraising. People using third-party fundraisers have particular problems. You need to be very careful to monitor that. There's a steady drumbeat that we see of data protection issues, with people becoming increasingly concerned about their data rights. And when I go on to the websites of many of the charities that we work with, I don't find that their privacy notices are compliant with the new post-COVID post-Brexit requirements. So, and these are things that can lead to not only embarrassment, but in recent years, the Information Commission has been much keener on fining people than it had to before. We'll talk a bit more about safeguarding later, but we're going to keep talking about that because it is absolutely the top of the list of the Charity Commission concerns. And in terms of reputational damage, one of the worst things that can go wrong. Advertising, great for a charity to advertise, but there are some strict advertising standards and you need to be careful not to cross any boundaries there. Health and safety tends to get a bit neglected. People think, well, we're insured, but you have to remember as a trustee that in the last resort, if there's a serious injury or death on your site or with your staff, trustees can be personally prosecuted. So it's an issue that you need to ensure is dealt with properly. That doesn't mean the whole board has to deal with it. You may set up a health and safety champion and ask them to do the grunt work of making sure that there are being fire assessments. But you as a trustee, when you're visiting, need to look round. Do you think this is a safe environment? Are you comfortable with the public coming into your shop or whatever else it is? Finally, HMRC. The problem that we most commonly come across is VAT. Charities aren't exempt from VAT, and quite a lot of charities have got to quite serious problems by not realizing they've got VAT issues. So it's worth asking your auditor explicitly, are they comfortable with the VAT treatment of all the things that you do? And if necessary, getting a specialist in on charity VAT to look at whether you're operating in the most effective way. Rachel. So in terms of regulation, we have one thing, and then we have the Charity Governance Code. So this was created by an alliance of voluntary organizations. It's not like the Charity Commission legally obligation, but it is something which is increasingly looked to as something which all trustee boards should take account of. And I think over the next 5 to 10 years, we'll come to a position where you will have to say in your annual report whether or not you comply with the Charity Governance Code. And if you don't, you'll need to explain why you don't. So basically, I think it's a very good thing. It's got 7 key areas of focus, and it's got very helpfully to short summaries, which alongside the essential trustee are, I think, 2 of the things that you as trustees should be reading. So clarity of purpose, we've talked about the importance of you really understanding not just your mission as you express it, but what your legal duties are. The areas in which we've seen a lot of development in the governance code, because we've just had a 3rd edition of it, are the area of integrity. So clearly we all want our charity to have the best possible reputation. And there's a lot in there about the steps necessary to maintain public confidence. But there's also beginning to be a new area of issue and concern in the sector, and that is power being used appropriately within the organization? I have to say that quite often you go to a charity board and you realize that one person is in fact dominating this board. It may be the chair, it may be the chief executive, or it may be a trustee who has perhaps got very strong views or was a founder of that charity. It is very important to understand and confront inappropriate uses of power and make sure that the board is a democratic organization in which all people have their say, in which all people can participate. Linked to that is the other big change in the Charity Code, which is the much greater emphasis on equality, diversity, and inclusion. It now asks that boards not only have an eye to this and a willingness to take steps, it's looking to see you approaching equality, diversity, and inclusion in a really systematic way, in having policies that deal with it, in having an action plan, in having targets, in having regular reviews of your achievement of those targets, and also undertaking the sort of training that is sometimes necessary to bring board members up to speed on what is a complex and developing area. So this touches on another area which I think is always important for boards and is much neglected, and that is training and updating for boards. We do this sort of brief updating here online, but a lot of our work involves working directly with boards, providing more bespoke training for them. And that goes across the range of specialisms. A board may need updating on accountancy. Not all of us come to a board with a full financial understanding. It may need updating on the risks and developments in the technology or science that affects your organization. Whatever it is, you've got to have a program to enable board members to fully participate and deliver. And that does involve making some investment in the field. So I think that equality, diversity, and inclusion is going to continue to grow as a focus, and that funders are already beginning to say that they want to see clear evidence of people addressing this area. And the Code of Governance now makes very clear guidelines as to how this should be done. The code deals with issues like the role of the chair and the vice chair. It is important to be really transparent about this. Chairs very often think that they are given powers by being given that title. They're given no powers in law. It's up to a board to decide what role they want from their chair. In order to make this governance code work, you need to do an internal review every year. And if you're a larger charity, and that means over $1 million turnover, you need to use someone like us or someone else to do an external review every 3 years. These external reviews, I think, are really useful because they allow you to surface issues which perhaps people have felt uncomfortable about surfacing, and also to bring a board up to date with where it really is against the fairly rigorous standards set out in the charity code. Rachel. So key commission requirements, serious incident reporting. Sukanya is going to be talking about that in detail, but there is a risk in reporting and a risk in not reporting. The risk in reporting is that the Commission feels free, if it feels it's interesting, to make what you've reported public. And so we try and craft for organisations who are making reports appropriate statements which discourage the Commission from publicising what we're reporting. The second risk is that you decide not to report, and in retrospect, the Commission don't like what you've not reported. If you're not going to report something that might be a serious incident, please, please, please have a carefully minuted decision about why you decided not to report it. We're moving towards much greater transparency, and do remember your auditors are going to contribute to that by making separate reports to the Commission about areas of concern. Sukanya mentioned the guidance which related to RNIB. This guidance now is moving from guidance to direction, and you need to be aware that not complying with a Charity Commission alert could lead to attention from the Commission. So in terms of conflicts of interest, Rachel, I think the problem that we see when we're doing governance reviews with charities is people not really understanding the full range of relationships and loyalties that can give rise to a conflict of interest. And in many ways, I think it's more often a problem of trustees not recognizing and declaring their conflicts of loyalties. So you can see here some of the things that you would need to declare, but also your employment, any public office, if you're involved in a campaign, hospitality that you received, if you are on your professional interests. So all these need to be declared. So essentially the process is declare, record it in a proper register, disclose that register to the board, and then manage those conflicts. Now, there's nothing wrong with having conflicts of interest or loyalty. Some of them are extremely trivial, but they still need to be declared. Much better to declare, because what we're looking at is not what actually causes you to behave in a distorted way, but what someone might think that might affect you. So do think about the notional reporter investigating the issue. So then you have to decide how to manage those conflicts, which may be simply to note them, or it may be to ask the person to leave the room. And then you need to record the action that you've taken every time you take action to manage those conflicts. And very often you may need, for very serious conflicts of interest, to consider whether it really works for that person to continue on the board if it's a continuing conflict. Sukanya, safeguarding.
Thank you, James. So safeguarding, it used to be just in relation to protecting vulnerable adults and children, but now the Charity Commission, particularly over the last few years, it says that safeguarding is much wider than this. It now relates to protecting beneficiaries, protecting staff, protecting volunteers, and basically anyone who may come into contact with the organisation during its activities. So this could be members of the public, for example. So what does this mean for you as an organisation, and how do you go about protecting all these different categories of individuals? Rachel, next slide, please. Thank you. The issues that have to be covered and people need to identify are pretty large now. It's sexual harassment, abuse, exploitation, physical or emotional abuse, bullying, harassment, commercial exploitation, which includes, for example, fraud within your organisation. The list is really quite extensive now. Bullying and harassment is an area where, if you read any third sector press, particularly over the last 6 months or so, there's been a real increase in the number of household names who have been found to have had a pervasive culture of bullying within their organisation. St John's Ambulance, for example, is one. In January, it was found that they paid over 1.1 million in severance payments to 15 members of staff in relation to allegations of bullying and harassment. That's a significant sum in any event, but given it was done at the same time of this course of a year following COVID, where they'd actually had to make an appeal for 6 million to keep the organisation going, it's a pretty dramatic effect of how the extent of bullying within an organisation, within the staff, can cause serious reputational issues for any organisation. Next slide, please. So managing safeguarding, you need to ensure, and the Charity Commission expects you to have, a clear complaints procedure. This is fundamentally so that any member of the public who is unhappy with something to do with your organisation could potentially look on your website, find the complaints procedure, and then make their complaint in accordance with that procedure. So we do encourage you to have a relevant policy on your website of your organisation. You should also consider the board reviewing your procedures and policies that you have in place. Do you, for example, have a safeguarding policy? Now, your safeguarding policy will often refer to and be read alongside your other policies, such as, anti-harassment, anti-bullying policy, your EDI policy. But it should also, for example, set out who people should contact if they believe that there's a safeguarding issue within their organisation. And you should also consider whether you have a whistleblowing policy. This is to enable any issue that might occur, which a volunteer or really a worker within your organisation becomes aware of, is then able to contact relevant individuals, hopefully within the organisation itself, so that the issue can be investigated and they can work out how it can be dealt with and to ensure that it doesn't happen again. The Charity Commission does also have on its website a form that any worker can use to report any whistleblowing event to the Charity Commission. And as we saw earlier, those have been increasing over the years, a 34% increase in that last year. You do need to be careful about your recruitment and your selection procedures. This is not just for trustees, but also in relation to any members of staff. Have you followed up on relevant references for staff members? Regarding your trustees, for example, have you checked that they are qualified to act? Have they signed a statement which fundamentally says there's no reason why they can't act? For example, they're not on the sex offenders register, they're not currently bankrupt, they're not a disqualified director. This is one of the particular areas that in that RNIB alert that I referred to earlier, they said that there were staff members working at that centre who were not qualified or trained in their actual duties, and similarly they had not been trained in respect of how to deal with safeguarding issues and protecting vulnerable children. Also consider exit procedures. If you find that you've got a number of people leaving in a particular department or within a charity, or if trustees are not staying their full term but just deciding to go, is there a reason behind it? And would an exit interview potentially help you understand what those reasons are and try and work out if there is a problem within the organisation, how you can deal with it? Next slide, Rachel. So here just basically sets out what, as a board, you should be considering in ensuring that you are dealing with safeguarding. You need to obviously identify proper procedures in place to ensure that all those who come into contact with your organisation are protected. But also, it will obviously be different from one organisation to another. If you're a small grant-making charity, there may not be so many safeguarding risks that you need to be aware of. But if you're a charity that works internationally or works in a conflict zone, then clearly there are going to be additional areas that you're going to have to cover to ensure that all staff and volunteers are protected. You do also want to try and create a culture of urgency response to these issues, but also a culture of speaking up so that employees feel, and as well as volunteers feel, it's appropriate to stand up and say that they believe that there's an issue occurring within the organisation. You don't want there to be secrecy, because that just leads to issues not being dealt with appropriately. Rich. This slide just basically diagrammatically shows out what the Charity Commission has said in relation to safeguarding. For example, it identifies that ideally you should obviously have a trustees code of conduct, which sets out the values of how trustees should behave and how they should deal with other members of staff. But similarly, that you have a staff code of conduct or a volunteers code of conduct as well, to ensure that people all are adhering to the values of your organisation and your charity. Next slide. So safeguarding is very strongly linked to serious incident reporting, and I mentioned that earlier. And fundamentally, a serious incident is an adverse event, actual or alleged, which results or risks significant harm to your charity's beneficiaries, to your staff, to your volunteers, anyone who may come into contact with the charity. So that's the concept of safeguarding coming into serious incident reporting. It's a loss of your charity's money or assets, or any detriment to your work of your organisation, or your reputation, or even damage to your charity's property. Now, this could be inadvertent damage. So, for example, you may have a flood at your one of your locations, and that obviously causes damage to your property. But it could be more draconian because, for example, you've been attacked by ransomware or there's been a cyber attack. It could be completely innocent. For example, we had a client who lost confidential information through no fault of their own because a courier van that was carrying the material was broken into. Something like that would obviously need to be reported to the Charity Commission, given the sensitive nature of the information, but also to the ICO. So do remember that if you are needing to make a report to one of your other regulators, such as HMRC or to Ofsted, then you should also be making a report to the Charity Commission as well. Significant clearly depends on the size of your organisation. It depends on your assets that you have, and what might be significant loss to one charity may not be significant to another. So you do need to consider how and when you should report. The Charity Commission strongly encourages all charities to report serious incidents if they believe it's going to affect the reputation not only of that charity but of the sector as a whole, or potentially could even be damaging to the Charity Commission. They do say that they believe there's serious underreporting, and they will consider whether charities working in the same sector of the charity world, if one is reporting more than the other, they will wonder why another organisation in the same sector is not reporting serious incidents. Next slide, please. So some of the serious incident reports that I've been involved with dealing with clients where, for example, during COVID, a bank couldn't get hold of relevant trustees. It closed one of the bank accounts. So the charity had no access to its main bank account. We obviously had to do a serious incident report to that, as well as getting the bank account reopened. We've had other incidents where, for example, a charity that works with the rehabilitation of offenders, a number of reports needed to be submitted because they deal with a number of very vulnerable people living in close proximity in hostels, etc. So a charity like that might be reporting almost on a monthly basis via a spreadsheet situation. The reason why it's so important to have a policy in place to understand how you're going to deal with serious incident reports and what actually constitutes a serious incident report is that you as trustees do need to sign off on your annual return each year to confirm that you're not aware of any serious incident report that has not been notified to the Charity Commission in the previous year. You can delegate, obviously, who submits a serious incident report, but the board should be made aware not only of serious incident reports, but also of any near misses that have potentially been avoided. And the Charity Commission said in relation to the RNIB alert that what was really quite damaging for the organisation was, despite Ofsted and also the Care Quality Commission being concerned and having raised concerns regarding the relevant peers centre, was that a serious incident report was only submitted by the trustees just days before Ofsted submitted a formal notice to close the charity. And that was what the Charity Commission believes is happening, is that not enough charities are reporting serious incidents. James.
Right. Well, I'm sorry, you might say, this is also scary. Why should any of us ever become trustees? And yes, that's the trouble with our job, is to alert you to issues you need to be careful about and issues you need to take care of. But it hasn't all been bad news this year. We had the long-awaited judgment on Kids Company. You'll recall that it went spectacularly bust. and the insolvency service then prosecuted the trustees, saying that they should have been aware that they had an unsustainable business model. The lady judge who made the judgment was very scathing about the insolvency service and said it was the duty of the courts to be generous and kind towards trustees. You give your time voluntarily, you do it without personal benefit, and it needed to recognize that charities often had what might be called at best an unstable business model, and that sometimes insolvency occurred. So yes, we all need to be careful, and yes, there are reputational risks if we get things wrong. Yes, we have to look at keeping our spending within the objects. We have to show we've been careful. We need to take advice on occasion. We need to be very careful if there's any kind of personal benefit, because the rules here are enormously strict and people often misunderstand them. Can I give you an example? We had an academic charity where one of the professors on the board was doing an awful lot of work on their journal. And so the university said, look, he's not doing so much of his university work. Can you compensate us? So the charity gave a grant to the university, and the Charity Commission said, oi, that's not okay. That's a personal benefit, because now the professor is able to do work for the charity, which is effectively paid for by the university, who's paying for it because the charity is giving them money. So do think carefully if there's ever personal benefit. But yes, there is potential for trustee liability. But Rachel, there are a number of things you can do about it. First of all, is you do need to review your insurance and to think whether you've got adequate cover. The really important insurances are about your activities and ensuring that they cover new activities or developments in what you're doing. Certainly, whenever you get a proposal on a board to move into a new area, you need to work out whether or not your existing insurances cover that. You can have trustee indemnity insurance. I'm not a huge fan of it. I haven't seen it adding much protection for trustees. Many trustees find it reassuring, and I wouldn't want to denigrate it, but it's also not a cover-all. It doesn't protect you from everything. So I think if we leave the situation with the words of the judge, which is that this country depends entirely on the voluntary efforts of you all out there to make the nearly 200,000 registered charities work, you are going to be treated, certainly by the courts and the law, as a group who requires our support and understanding, rather than people who need to be kicked around. Although occasionally the Commission is a little tougher on people than I'd like to see them being. But that's, I think, because of their own internal agenda. So we've now got time for some questions. Next slide. These are some of the things that we would suggest you look at. And Rachel, what questions do we have?
Okay, I'm just having a quick look. So the first question that came in, a new trustee is proving disruptive. Can the others remove them?
Well, one would hope so. There's almost always a route to removal of some sort, but that does involve looking carefully at the Constitution. So it might be that a simple vote on the board would do it. It might be that you had to go back to the membership. So I'm sorry that we can't be absolutely clear about that.
So next one was small grant-making charities where the trustees don't have staff can struggle when different trustees have different views on how to run the charity.
Well, achieving some kind of teamwork and consensus is something that needs to be worked at, and there are a number of ways of doing that. Obviously, you need to start from fundamentals. What is the mission of this small grant-making charity? Why is it there? And how is it going to do what it's doing? It has to be said that not all difficulties are overcomable, and sometimes the majority group on the board needs to take a view that there are trustees who fundamentally disagree with the way the charity is going. but they are a minority, and maybe it's not a good idea to have this internal tension. Maybe it's a healthy tension and maybe it's not, but you do occasionally need to confront the fact that the board isn't functioning well and needs to be reconstituted.
Next one is, so I think this is talking about a small charity which is founded by someone who's also acting as the CEO, and they attend trustee meetings. And the question is, can they also be a trustee?
Sukanya?
Yeah, basically the position is that if you're a CEO, then I presume you're obviously in a paid position and an employee, and therefore you wouldn't be a trustee as well, because one of the standing rules is that you should not be in paid employment. Obviously, it depends. In respect to the charity, it obviously depends on your constitution. There are occasions where we've acted and we've got relevant consent for a particular CEO to be a trustee as well and have voting rights, etc. on the board. But it is quite unusual. It depends how your organisation is set up. You said it's a small charity. I'm not sure if it's a company or not, but it's not something you can standard process to have. It would be very unusual, and you'd need a charity commission if you're an unpaid employee.
So the next person is from a younger person who's a trustee and feels that they've less experience. I mean, I think we all need to recognise that boards need, in many cases, to try and recruit people with more diverse lived experience, and that includes a wider range of age than is typical. I think there are a couple of issues. The first is that boards should take steps to help people who've got different life experiences or different sets of skills participate fully. And that may mean providing them with some extra assistance, perhaps sitting them down with the accountants or the treasurer or the finance director so that they get a real understanding of the meaning of the figures. I know many of us would benefit from that. There are other approaches. There are some charities who've wanted to recruit really young people and have felt that having youth ambassadors to the board, people who join the board not as voting members of the board, but as advisors on youth issues, can be a helpful way. So you need to think creatively. There is a certain minimum level of skill that you need to have. So Henya was saying that Companies Act require you to have the level of skill and experience that would be expected of the director of a company, if you're a company of that size. And so your skill level and experience needs to be appropriate. But there's absolutely no reason why you shouldn't ask for additional support if you feel that your experience is less than others. So Henya, conflicts?
Yeah, there's a question here. Can you give an example of conflict of interest? My partner is on the county council, political board, cabinet, the commission services my charity contender for. Is this a conflict of interest? Well, potentially there's two areas of conflict of interest in that scenario, because obviously your partner would, when a tender comes in from your charity and they obviously you're connected to them, they potentially also have a conflict of interest in respect of their connection with yourself. When you're a typical example of conflict of interest is where, for example, your partner is on a board of an accountancy firm, for example, a partner there, and your board is your charity is thinking about tendering for a new accountant. And there's a concept of there being a conflict of interest, because clearly you could get an indirect benefit, and also you'd obviously see relevant papers in relation to the other tenders. And that's a situation where you should be declaring your conflict, saying that you won't look at those relevant papers because you don't want to get almost an inside track, as it were, on that issue.
So Sarah, you ask about how quickly do serious incident reports need to be made. Well, it very much depends on how serious the incident is. If there are very serious allegations about the behaviour of your chief executive, you probably need to alert the commission that they've been made, even though you haven't yet investigated them. If there is perhaps a financial loss that you can't quite identify, you may well say, well, we'll do the investigation and notify later. It's a question of judgment, and people often phone us up, and I think it's quite often sensible to put in a preliminary serious incident report and then report more fully once you've dug down to the bottom of the issue. There has been a request in the past by the Commission to report serious incidents that failed to be reported in previous eras. That's quite problematic. If you're thinking about doing that, I would take some advice, because you have each year signed a form which says there have been no serious incidents that have not been reported. So all trustees have put their hands up and said all serious incident reports have been reported. So if you've gone over that year limit, there can be more difficult issues.
There's another question here about serious incident reporting. Can you give more details about submitting via spreadsheet? Charity Commission couldn't give me guidance on this. This is because the Charity Commission has changed their form, and so you aren't able to now attach any documents, which is rather unhelpful. Whereas before you could submit a relevant spreadsheet. But what I do suggest is that when you submit a serious incident to the Charity Commission, that you potentially on that form also refer to the fact that you wish to be able to submit more in one go, as it were, and see if they come back with anything helpful on that. But it's likely that you should put it within your serious incident report, that question, because otherwise it's very difficult to get a response from the Charity Commission in the right department.
Yeah, and my experience is that they're moving away from accepting big reports. But we have a number of our clients who continue to do that just because they've got large operations and there are many issues that need to be reported, and they can't handle it effectively otherwise. Nigel asks, what type of insurance should trustees take out themselves, and can this be covered by the charity? It's pretty inefficient to insure yourself. It would be much cheaper for the organisation, the charity, to insure all trustees, and it generally can be covered in a modern constitution. We haven't talked much about constitutions, but some of you out there will have constitutions that are seriously out of date and need updating. So insurance for a trustee is a trustee benefit. The Commission would permit it if you asked, or if your constitution asked. But if you've got an old constitution, there may not be provisions that allow you to provide that kind of benefit for trustees. So the answer is, look at your constitution, which may need updating, and then have a discussion at the board as to whether it's good value. It is, an ongoing expense, and for smaller charities, you need to think carefully whether you really need it. So Henya, hiring a new trustee in the SMT.
Yes, so sorry, the question here is, how much should the SMT be involved in hiring new trustees? Should the CEO be heavily involved? Well, obviously it depends on your constitution and how the setup of your organisation is. I mean, are trustees being potentially elected by members or by other trustees simply appointing them? Normally it's within the board itself that you'd be considering who, after you've got the relevant applicants in, who you would be considering to employ. Its final decision really rests within the board itself, depending on what your constitution says. So whilst the CEO would be involved potentially in the whole process and may be involved in discussions, it wouldn't be a final decision that would generally come to the CEO in that regard. It's more for the board within itself to determine that.
And I think that there can be issues where staff become too involved in trustee selection. I mean, trustees are their employer, and while it's good that there is a healthy dialogue between the senior management team and the chief executive and trustees, the trustees also need to be in a position to offer some challenge and stretch to those people. So having too much input is a bad idea, but certainly allowing SMT to comment perhaps on the shortlisting, but I think the responsibility should stay firmly with trustees.
There's another question here. Can you be a trustee for too long at a charity? Is there a length of time recommended? Well, the Charity Governance Code recommends 9 years, like 3 terms, for example, of 3 years. And then after that, there should be, strong reasons as to why the board has continued to have a trustee on for a longer period of time. But some people just do 2 terms of 4 years, for example. But what you don't want to see is somebody being on the board forever, unless potentially they're a founder trustee. So the Charity Commission does like you to have relevant and regular, re-elections of trustees or reappointments after a 3-year term, for example?
That's the ideal situation. In quite a lot of small charities, frankly, recruiting trustees is quite difficult. Sometimes it's difficult because people aren't investing enough in the recruitment process, not putting enough time and energy. There are some good websites out there which will find people, but there are no legal rules as to how long trustees can sit. And I have to confess, having been a trustee of one grant maker for 25 years, so I'm not exactly a purveyor of best practice in this area. But that was because it was a relatively small family trust, and it was appropriate for that to happen. So there is the best practice, which Sukanya's talked about, and there is what happens on the ground. So the final thing, obviously, is that many constitutions now contain provisions limiting the length of service. So you do have to look back at your constitution and see that it's okay. Now we've got a difficult issue about what are trustees' liabilities in respect of COVID if a charity property is sublet to children's nursery or to a Keep Fit club. Well, normally the person operating the entity inside charity premises is liable for the COVID compliance. Certainly, if you were aware that non-compliant behavior was going on, you would want to take some action insofar as your lease allowed you to. But generally, the person operating a nursery or a club has the duties under COVID to safeguard people. That doesn't free the trustees from overall liability, and certainly there are reputational issues which go beyond legal issues, which would mean that you would perhaps want to be really confident that your premises were being used in a COVID safe way. I don't think either Sukanya or I particularly want to dive into the depths of VAT,
No.
but broadly, that is a complex subject and applies to services provided by charities where they're charging for it. And sadly, charities have to pay VAT. So there are important and complex issues here, because not only do you want to make sure that you charge VAT when you need to, but you also need to ensure that you recover as much VAT as you possibly can. And there are ways of structuring charities by setting up trading subsidiaries that can vastly increase your VAT recovery. So if you wanted to talk about that in more detail, it's probably best to give us a ring.
The question here, how can we draft I presume they mean a serious incident report to the Charities Commission that discourages them making it public? Fundamentally, what we do is to try to put in a relevant paragraph which encourages the Charity Commission to get in touch with us first before they potentially go public. We don't have a right to, we can only have a right to ask. We don't know if they'll actually follow through with that. Obviously, Charity Commission is subject to Freedom of Information Act requests. So we often put in a provision there as well to say we don't, this could detrimentally affect our organisation or our reputation of our organisation. If this was to go public, we strongly encourage you, please, to get in touch with us before the Charity Commission releases any information referred to in the report. So it's really more of a request to the Charity Commission at that stage.
Sukanya, there's a question here about the example you gave of a charity working in the criminal justice field needing to report serious incident regularly. Why was this?
No, it wasn't that so much that they had to report regularly. It's just that you may find that where you, if you're a simple grant making charity, you're probably not going to come across too many serious incidents unless you're, have ransomware or cyber attack on your organisation, for example. But where you work with rehabilitation of offenders, where they're in lots of hostels being run by the organisation, many of the beneficiaries have mental health issues as well as addiction issues. There can be more volatile scenarios that potentially could arise, and therefore you might have to, as a charity working in that sector, have to make more reports there than you fundamentally would, say, in a simple grant making charity. That was the only point that I was making.
So the next question is, should funders also be trustees? Well, it comes back to management of conflicts of interest and conflicts of duty. Certainly many charities have close relationships with their funders, and sometimes that results in people nominated by the funder or the funder themselves having someone on the board. So, for example, a local authority may fund a community centre and want to have someone on the board of that community centre. So that's perfectly possible. You should, of course, have a quorum of trustees who can make decisions without the funder present if an issue about the funding comes up. So if the funding is up for renewal and there needs to be discussion about your strategy to retain funding in future, you would probably need to ask the funder not to take part in that discussion and to leave the room. So it's a question of managing the conflict of interest that arises where someone wears both the hat of a funder and the hat of a trustee. So Henya, there's a question about salary. If you don't draw a salary, is that okay?
I think this might link back to the CEO question. I'm not sure, but I think it does. Well, basically, if you're a CEO and you're not drawing any salary, you're not an employee and you're not getting any other benefit, then potentially that's a situation where you could be on the board. But it'd be quite unusual to have somebody who's a CEO who's not employed within the organization. It could be that you're referring here more to the sort of trustee, founder trustee being on the board itself, which obviously would be fine. It's just a question of whether they're receiving any financial benefit or other material benefit, and that will be set out in your constitution, which would normally say, for example, if it's a charitable company, that you cannot receive any benefits or be an employee of the organisation unless you have relevant Charity Commission consent or subject to the constitution itself.
So then we have a question about, have we seen best-in-class examples of increasing user representation on trustee boards, given that it's not always that they don't always have the required skills or appetite for liability? Well, this is a difficult issue, and there are very different views in this. Some people feel that it's essential to have some users on the board. Others say we have broad range of users scattered across a big geographical area. Having one or two individuals who are users on the board is tokenism. Some people, as I've said, have approached the issue of getting people who are a bit nervous about joining a board, who don't have the skills, by setting up some form of ambassador arrangement. Some people have consultative councils which meet with the board regularly and bring together groups of users outside the board responsibilities. And some people think that having users on the board is fine and say that they get a great deal from it, but they very often have to put in more work in terms of supporting those individuals and training them so that they can properly discharge their responsibilities. You can't have someone whose level of understanding is such that they can't act as an effective trustee. We're all obviously got different sets of skills, but it's not the case that someone is excused from having those skills if they're a beneficiary or a user of the organization's services. So Henya.
Just going through them. Where's the next? This one I don't think we've covered yet. Is it usual, for trustees to stay in close contact in between board meetings? I'm a new trustee and I've got lots of ideas, but don't know how to bring these up. I think this is a particular issue during COVID because obviously people haven't been able to meet up and have the sort of general chit chats before the meeting starts and after the meeting. So what I would encourage you to do is you have to break that sort of Zoom barrier, as it were, and not just have your main board meetings, but also have, as James mentioned earlier, potentially where you have a meetup session, be it virtually or otherwise, before the actual main board meetings, just so that people can catch up and maybe just have a bit of a brainstorming session rather than just dealing with some of the key agenda items that you would normally have in the board itself.
The next question, it raises something that we see quite a lot. The question is, in our local Scout group, we have 4 trustees registered with the Commission. However, Scouting seems to be saying that all uniform leaders are automatically opted in as trustees. Is there a concept of different types of trustees not registered with the Charity Commission? Well, A charity trustee is somebody who has a share in the control of the organization. So it's a question of fact. If the uniformed leaders or anybody else is working with the registered trustees in running the organization and making decisions about budgets and activities and goals, then they're a charity trustee and must be registered with the commission, just like the other trustees. So there isn't any concept of separate sort of trustees. And indeed, I think it's quite a dangerous idea, because if people come to meetings and take part in decisions, then they need to be properly registered with the Charity Commission and recognise that all trustees share the same duties together. Next, we have a question about how does the board undertake its annual review of its own performance? Well, there's a number of ways of doing this. Typically, it starts with having a strategy and a business plan, and looking at how the board has contributed to achieving that strategy and business plan. Very often there's a separate exercise in reviewing the performance of individual trustees. Often that's undertaken by the chair, where you look at attendance. Are people participating in meetings? Are they do they complete their induction properly? Is there a evidence that they're examining what goes on in the organization and learning so that they can contribute properly? So there are two issues. One is, how does the board perform as a unit directing this charity? And the second is, how do the individuals within it, including feedback on how the chair chairs it, do in running the organization? And increasingly, people on this second area are using 360-degree arrangements, because it's also interesting to see how the staff view the board as delivering its mission. So Henya.
There's one here. If you are a new startup organisation, who would recruit trustees? I presume here you're talking about a new charity setting up. It would normally be the initial trustees who would be, they're normally going to be one or at least two. When you set up a charity, you need to have 3 when you register it with the Charity Commission. So initially, the first 1 or 2 should be getting together and thinking who they might want to have on join the board with them. Often this relates to somebody who might be related to them or a good friend initially. And it's then going forward, the board will then need to consider who are the most appropriate with the different sets of skills who could potentially join the board. There are a lot of, if you look on the NCVO website, it gives information about where are potential places to recruit new trustees to your organisation, as well as where you should potentially advertise them, and different sites do that.
There's a question here. If you set up a small charity, can the person who runs it day to day, the CEO of the charity, as well as giving their experience, be a trustee? Well, this comes back to this payment arrangement. Unusual for small charities to have power to pay a trustee, and therefore not possible for the CEO to join the board without commission consent. And Ms. Milligan's been appointed to a charity which is winding up, which wasn't flagged to her before she joined a charity. The staff are being made redundant, and the trustees want to run the charity itself. How operational should you be as a charity? Well, frankly, it varies enormously. I'm a trustee of a small charity here in Swanage, and we have no staff, so we're all entirely operational. I'm also a trustee of a large international charity where I'm not at all operational. So it's great if you've got staff to do things or volunteers to do things, but in many charities, it is the trustees who run the charity and deliver the operational outputs. It's a lot of work, but it's how many organizations work, and why this organization is called part of the voluntary sector. So Henya.
Could the CEO of the charity chair trustee meetings, given that they know the issues discussed in detail? Well, fundamentally, you should check what your constitution says. Normally, it would say that it's the chair that will chair the meetings. It's quite unusual. It's fine for the CEO to be in attendance for parts of board meetings, particularly, as you said, because they have the information and to then discuss those particular items on the agenda. But depending on the size of the organisation, especially larger organisations, we tend to see where you might have trustee-only meetings, but that would have preferred before that you would have had trustees together with, say, the CEO and any particular other members of the SMT, for example, the finance director, also being in a meeting. But you wouldn't generally have the CEO of the charity chairing trustee meetings. But it does obviously check your constitution, check the size of your organisation, but it's quite unusual. They should really only be in attendance for those sections of the meeting that are appropriate so that the board can act together on trustee matters.
I would very much agree with you, Sukanya. I think it's pretty unhealthy that there's even a suggestion that the chief executive should chair, however much they know. The trustees represent the organisation, the employer, and they employ the CEO. So it's the CEO reporting to the trustee board, and with that relationship, it's entirely inappropriate for a chief executive to chair, and might be an indication. We talked earlier about the idea of integrity in the code. I think many people would see a CEO seeking to chair a board meeting as being evidence of inappropriate use of power and not good integrity within a board. Sukanya.
I'm seeing a question here. If 1/3 of the trustees of your board resigns before their term, would you recommend exit interviews? Can you insist on those exit interviews? You can't insist at all on exit interviews. I mean, you like to think that people all leave amicably, and that you can get a bit of insight potentially from having a chat with somebody as to why they're going. I presume you're suggesting that all of these individuals have left at the same time in one go. It may be that you can identify potentially why that's happened within the board. Has there been a major disagreement within the board and a split within the board itself? But whilst obviously do encourage them to have a chat with the chair and to understand what happened, you can't insist on it, unfortunately.
Rachel, do you have any input on that?
No, nothing to add to that.
No, okay. Jeffrey asked, does not the greatest value of trustee liability insurance lie in covering costs which would be incurred by trustees in defending or reacting to any claims which may be made, rather than protection against sums which the trustees may be required to pay as a result of the claim, bearing in mind that many charities are not of a size which enables them to indemnify trustees from the charity resources? Certainly, that is an advantage of trustee liability insurance. It's one, as I said, that we haven't seen large numbers of payments to trustees under these policies, and there is a significant annual cost. So you have to balance the cost and the degree of risk that you think you face. Clearly, for most charities, the most sensible risk management thing that they can do is to achieve limited liability status, either through becoming a company limited by guarantee or becoming a charitable incorporated organization, a CIO. And that's clearly, there's an initial cost of doing that, but it's a one-off cost rather than an annual and often increasing cost. Can board pay nominally even members of a consultative council? Sukanya.
What skill set is required to be a trustee, and what can you do if you feel there is nepotism in the charity? Regarding skill set, we basically are looking at those duties that we talked about earlier and what you're trying to achieve within your organisation. Clearly, if you're in a charity that deals predominantly, say, with working with vulnerable children, then somebody who has, for example, social care experience would obviously be beneficial. But similarly, you might be looking for a skill set because you need somebody with finance experience. So it doesn't need to directly relate, as it were, to the sector, within the sector that you're working in. When you asked about if you feel there is nepotism in the charity, I'm not sure if you're talking in relation to trustees being appointed, or really if you're talking here about obviously an employed position. well, it's quite difficult depending on what your position is in with the organisation. But if it's somebody, if you're on the board, for example, and you believe that there is some form of nepotism going on in relation to employment of staff, then clearly that's something that you should be raising with the people who are dealing with recruitment, and also who potentially fail to declare a potential conflict of interest or family connection if it was somebody particularly within the board itself.
Nigel asked an interesting question. They have an employee who cleans and manages and sublets the property for a minimal charge due to their love for the charity. Does this conflict with employment law? It does indeed, I'm afraid, raise issues, because anyone who is working as an employee is entitled to the national minimum wage and is entitled to paid time off as holiday. And if someone accepts lower than that, they can retrospectively claim the amount that would take their salary back up to the minimum wage for the work that they've been doing at below cost. Now, it is possible for an employee to also volunteer for a charity, but you need to have really clear separation between what the employee does as an employee and make sure that they're properly insured, paid, and health and safety, etc., for that period of their work, and what they do as a volunteer, which needs to be dealt with under a separate volunteering agreement. So this arrangement with a minimal charge seems to sort of cross over the boundary between the two. And to be frank, it may well work out with no problems for anyone, but it is a problem waiting to happen, given the rules about national minimum wage and other issues. Sukanya.
With more charities using technology, especially since the start of the pandemic, do you have any advice on things charities must be mindful of? You mentioned GDPR, privacy settings on websites, social media, tweets, any others. I think for a start, you obviously need to ensure that you've got a, for example, a social media policies, particularly regarding your employees and how they, and your trustees to that extent, deal with any messages that they might put out on social media. So we've had situations before where inappropriate messages have been put out by employees of an organisation. It's then led to potentially arguments between people who've put out the original tweet and others who have then joined the conversation. And that can be pretty significant. It can have obviously have reputational issues for your organisation. So you do need to ensure that people within the organisation, both volunteers and employees, are aware of what is and what is not allowed as a result of how they engage with social media, particularly where they represent the organisation or where they're making statements in respect of the organisation itself.
Well, we must be thinking about drawing this to an end, so we'll answer a couple more. One of the questions was, can the board pay, even nominally, members of a consultative council? Well, as we were talking about earlier, if you're wanting to involve users or other people who perhaps don't want to come onto the board or who don't have the skills to come onto the board, a consultative council is often a very good idea. And there is no reason, if they're not trustees, why they should not be paid, provided you've got powers in your constitution to do that. And it's unlikely that you won't do that. You do need to be a bit careful. Obviously, the taxman may become interested in the nature of the payments, and you don't want to run into any liability for PAYE or to create a relationship of employment. So I think it's a question of whether it's simply reimbursing expenses for example, for travel or for child minding to enable people to join the consultative council, or whether it's some kind of other payment. Do be careful. People in the past used to use the phrase, well, we're just paying an honorarium. The Inland Revenue is not very keen on these and will tend to treat them as a payment of salary when you might have a PAYE or national insurance liability. Last one from you, Sukanya.
What's this? That's somebody who has to go. Are small charities without paid staff an annual income of less than £5,000 required to submit trustee report? I think the position here is that if you're a charity and you're registered with the Charity Commission, because you've obviously got an annual income of if it's under 5,000, you don't have to be registered with Charity Commission. However, if you're already registered, you do need to be careful that you're still complying with all of your requirements. And I do believe that obviously you still would need to file relevant report in regards to what's been going on for the previous financial year. The 5,000 limit is where you're starting off as a new charity. If it's under £5,000, you don't have to be registered. But once you are registered, you need to follow through.
The only wrinkle on that is if you're a charitable incorporated organisation, you can register under 5,000 a year, and then you would be having to put in reports. Thank you for you all. For those of you whose questions haven't been answered, or anybody who thinks of something later, please do send us the questions. We're very happy to answer them. It's been great having all this feedback and the questions, and I hope you found that useful. We will be doing that again. Do watch our website for details of further sessions of this sort. So from myself and from Sukanya, thank you, and we very much enjoyed talking to you.